button your Bible and raise your right.
We're back at the State Bar hearing, disciplinary hearing. Mike Nifong getting ready to take the stand. But let's listen in.
Michael Byron Nifong.
Where were you born, Mr. Nifong?
In Wilmington, North Carolina.
And where did you attend college?
At University of North Carolina at Chapel Hill.
When did you graduate?
In 1971.
With a degree in what?
I had an AB in political science.
And after you graduated from the University of North Carolina at Chapel Hill, what did you do?
For the first year after graduation, I was a teacher of mathematics and boys physical education in Southport. Thereafter, I spent 3 years as a social worker in the Department of Social Services in New Hanover County, Wilmington. After you stopped being a social worker, what did you do? I retired from the profession of social work to attend law school starting in the 1975-1976 school year at the University of North Carolina at Chapel Hill.
And when did you graduate from Chapel Hill?
In May of 1978.
And did you sit for the bar that summer?
I did.
And you become licensed in that summer?
Yes, sir, in August of 1978.
Okay. What did you do as far as employment after you graduated from law school in 78?
When I was in law school, I decided that I really wanted to be a trial attorney. That was my goal. And I felt that the best opportunity to get that experience would be to start off with the district attorney's office. And so I set about to find a job with the district attorney's office, preferably somewhere close to where I lived at the time, which was in Carrboro, suburb of Chapel Hill, and was unable to find any district attorney's office with a job opening at that time. So I had interviewed with several, and the most hopeful seemed to be in Durham. And so I went back to the then sitting district attorney, Dan K. Edwards Jr., and I told him that I was so interested in working in a district attorney's office that I would be willing to work for free if he would give me an opportunity to be in the courtroom. And he said that he would do that. And so sometime in October of 1978, I started working on a per diem, just on a volunteer capacity initially, in the district attorney's office in Durham. I was an assistant district attorney in district court. And after about 2 weeks of that, he said that he was going to find me some per diem money. And starting, I think, on November the 8th of 1978, I became a full-time per diem assistant district attorney. Continued in that capacity until April of 1979, when I was hired for the first opening for that.
If you could, did you progress in different stages in the DA's office while you were there, as far as district court, superior court?
Yes, sir. I started off in district court in the end of October of 1978. In June of 1979, I moved to Superior Court and was in Superior Court from that point forward. About 2 months after I became a full-time assistant DA, I was in Superior Court.
At some point in your career, did you cease trying cases in Superior Court?
Yes, sir. In 1999, at which time I was, I guess people would consider, I was the chief assistant district attorney, and I was considered one of the, probably the primary big case trial attorney in Durham. I was diagnosed in that year with prostate cancer.
And before that, in your Superior Court practice from, say, 1990 up to 1999, what were the type cases in Superior Court that you tried?
During that period of time, I tried almost exclusively crimes of violence. During the first part of that decade, maybe the first half of the 90s, I would have tried some rape cases in addition to armed robberies and homicides and things of that nature. At some point, fairly early in the 90s, we started specializing some of our Superior Court staff so that at that point I had fewer rape cases, and there were people in the office that handled most of the rape prosecutions.
from the mid-'90s, from 1990 up until 1999, when was it in that period that you would have tried or handled your last rape case?
I don't have a specific recollection, but I would guess sometime around 1994 or 1995.
And as an assistant district attorney, how often is it that you deal with expert testimony and expert reports other than reports that are generated or compiled by the SBI?
I don't know specifically about today, but I can tell you that when I was involved in the regular prosecution of cases involving expert testimony, that prior to this case, I only had one case that involved laboratory work from someplace other than the SBI. That was a DNA case where we had a cell mark laboratory that did some work. I guess that was most likely in the early 90s.
So from 1990 up until this case, you would have had
just one incident of dealing with a laboratory other than the SBI laboratory.
When did you become the district attorney in Durham County?
In April of 2005.
And how is it that you became the district attorney? Were you elected?
Not at that time. The sitting district attorney was Jim Harden Jr. He had been the district attorney in Durham since, I believe, about 1993. And he came to me in April of 2005 and indicated that he had an opportunity to become a Superior Court judge and wondered if I would be interested in applying for or being considered for the position of district attorney for the remainder of his term.
From the period of time of 1999 when you were diagnosed with cancer up until you became the district attorney, what were your duties and responsibilities in the DA's office in Durham?
Well, when I returned from the first phase of my cancer treatment, I was pretty much restricted to desk duty. And as a result of that, was looking for something I could do to help the office that did not require being in a courtroom. We had just had an incident in Durham involving a drunk driving case that had resulted in the suspension of the license of a private practice attorney, and it also resulted, I think, in a censure of actually a private practice attorney and a member of the district attorney's office, and there was also a censure of another assistant DA. And so there was a perception that things were not the way that they should be in traffic court. So I was sent to traffic court because that was a desk job where Mr. Harden felt that he needed someone with some authority to man that position until some sense of order could be restored.
And from the time you became the district attorney in Durham County until March of 2006, how many Superior Court trial matters did you personally handle?
I did not handle any during the period of time between when I became, actually, from the time that I received treatment for cancer, I did not handle any Superior Court matters.
From the time that you became a district attorney in Durham County until you ceased doing Superior Court cases, did you try many jury trials?
You mean prior to 1999?
Yeah, from the time you went there up to 99.
Yes, sir. It was probably a little over 300.
Moving forward to March of 2006, when did you first become aware of the events that have come to be known as the Duke Lacrosse case?
On the afternoon of March the 23rd of 2006, I left one of the doors of my office and walked over to a copy machine that is outside that door. And sitting on the copy machine, I saw a copy of the affidavit for a non-testimonial order for a number of individuals. I had never seen anything that looked like that before, so I picked it up and read it and determined that It was an affidavit for a non-testimonial order for all the Caucasian members of the Duke of Cross team involving an alleged sexual assault that had occurred sometime on the evening of March 13th and the early morning hours of March 14th of 2006.
If you could turn to Exhibit 203 in the notebook up there, please.
Yes, sir.
Can you identify that document?
Yes, sir. This appears to be a copy of the same application and order for non-testimonial identification that I found in the copy machine on that day.
Prior to seeing that order, over the course of your career, had you been involved in obtaining non-testimonial identification?
Yes, sir.
In your experience over that period of time, what was the largest number of individuals that would have been included in a non-testimonial identification order that you would have applied for?
And all the ones that I've ever applied for, there was only one.
And in your
Wait a minute. Can you repeat that answer? I didn't quite get it.
I'm sorry. In all the non-testimonial orders that I had actually filled out myself, there was only a single individual that we were looking for non-testimonial identification from.
All right. Thank you.
Now, in your office at March 2006, did you have an individual who generally was in charge of handling sexual offense cases?
We actually had more than one. We had Tracy Klein was the primary prosecutor for adult sexual offense cases, that is, sexual offense cases with adult victims. And then we had a couple of people that dealt with prosecutions where they were child victims.
And on this order, do you see the name of an assistant district attorney who will have filled out that application?
Yes, sir. It's my chief assistant, David Sachs.
And in March of 2006, what were his primary duties and responsibilities in the Durham DA's office?
Well, as my chief assistant, he had supervisory authority over matters that arose when I was unavailable. He had duties, in essence, for running the district court, the superior court docket to make sure that the case management rules were followed and things went along as they should. And then, of course, because he did carry a caseload himself, which consisted of non-sexual assault crimes of violence and drug trafficking cases, then he would be somebody that would often be consulted in matters involving trial strategies and things of that nature, too.
When you saw the document that's marked as Exhibit 203, did you have any conversations with Mr. Sachs or anybody else in the office about it?
I asked Mr. Sachs about it as soon as I could. It was that same afternoon.
And what sort of information did Mr. Sachs provide you concerning that document?
What he indicated to me was that the investigators in this case, Mr. Gottlieb and Mr. Hyman, had originally come to Ms. Klein, as I would have expected they would have in this case, and asked for her assistance with the non-testimonial order. She had told them what they needed to do, that they had drafted something and brought it back. She was unavailable, so he had assisted them.
And did you talk to Ms. Klein about this document at all?
I don't recall that I did at that time. Actually, about the document, I don't recall ever talking to her about the document.
Okay. Did you ever have an opportunity to talk to her about the underlying criminal case that ensued from this non-testimonial identification order?
Yes, sir.
And when did you talk to her about that first, that you recall?
I don't recall the exact date, but my guess is it would have been the week of the 27th of March.
Okay. And when is it that you first were briefed on well, strike that question. Let me go back to Exhibit 203 and go to the page that's entitled at the bottom right, 461.
Yes, sir.
And in the last paragraph of that document, there's language that is in that document that says DNA evidence requested will immediately rule out any innocent persons and show conclusive evidence as to who the suspects are alleged in the violent attack upon this victim. You see that?
I see that, yes, sir.
Do you think that language is correct?
I know that that's the language that's in there. It is not language that I would have included in a non-testimonial order had I drafted it.
Okay. But it was a representative of your office that signed off on that document, is that right?
That's correct.
And you have confidence in Mr. Sachs to handle things for you when you're not in the office to run the day-to-day operations of the DA's office, right?
Yes, sir, I do.
So you don't disagree with the fact that that's in there, right?
It's unquestionably in there, yes, sir.
And you don't disagree or have any problems with the fact that Mr. Sachs signed that order, is that right?
No, sir.
Now, at some point in time, were you briefed by the investigators on the underlying facts of the Duke lacrosse case?
Yes, sir. Sometime, I would estimate mid-morning of the date of Monday, March the 27th.
And could you tell me who it was that briefed you on the facts of this case?
The people that arrived at that time were Sergeant Mark Gottlieb and Investigator Ben Hyman. I had called Station 2's captain, Jeff Lamb, on the previous Friday and indicated that I had learned of the case, that I wanted to be kept up to date on what was happening with the case, that I would like to be briefed on what the officers knew about it up until that time, and that they had any further requests for court orders or anything to bring those to my attention.
Had you done that on any other cases since you were appointed the DA in Durham County?
No, sir.
Why was it that you felt that you needed to do that in this particular case?
I knew that the non-testimonial identification order would be turned in to the clerk's office, that it was a public record, that it would be seen by the media, and I expected that their reaction would be similar to mine, which was, I've never seen anything like this before, and that they would read it, and that when they did, they would read the allegations of the assault that took place at this address where the police were focusing on members of the Duke lacrosse team, and I felt that that would be something that would garner a significant amount of media attention.
You said you hadn't seen anything like this before. What do you mean by that?
Well, I've never seen a non-testimonial identification order with 46 names on it, and that was the first thing that drew my attention to it. And then when you read the allegations are rather sordid, and under the circumstances, I felt that it was something that would garner a lot of media attention.
And when you first met with the officers on Monday the 27th, I believe it was, can you tell me what information you were provided about the status of their investigation?
It's hard for me to tell you precisely what I might have received on that first morning, because I met with them for several times during that week. But initially, they did not bring a whole lot of stuff with them. My recollection is, and it is possible that some of these things I did not see until a day or two later, but my recollection is that I did see a statement from a Mr. Jason Bissey, who was a neighbor, that I did see statements from Mr. Zash, Mr. Evans, and Mr. Flannery, who were the residents of the house, that I was also shown, I'm not sure about the complete report, but I think some copies of part of the sexual assault nurse examiner's report. I don't know if I actually saw statements from the victim or the other dancer at that time. For some reason, I'm thinking that they might not have had those when they came to see me that day, but I'm not certain about that. I don't recall seeing any what we call incident reports, officers' initial reports or anything at that time. But I did have the officers who had done some of the activity, and they could tell me about what had gone on.
What, if any, verbal communications did the officers give you about what steps they'd performed in their investigation at that time that you recall?
Well, I was told that the case came to light as a result of initially a call being received by Durham Police Communications indicating that racial slurs were being passed by people standing in a particular location in Durham at a car that was passing by containing African American females. That call came in that an officer went to that location, and when he went to the location, he found no one at home. There was a residence there, that there was evidence of perhaps a party had been there. He could see in through the window and see things like kegs of beer, cups of that nature. That it did not appear that anyone was home. No one came to the door. There was nobody standing in the yard. That he walked around the house. He did not see any items that called attention to themselves at any place around the residence, and that he called in essentially that nobody was home. Sometime later that evening, the same officer responded to the parking lot of a Kroger store in Durham, and when he arrived there, he found two African American females in a car. One of them was the driver of the car, and there was somebody in the back seat that turned out to be Miss Mangum, who did not want to leave the car. And so there was some discussion at that point. Officer Shelton appears to have initially made the assumption that he was dealing with someone who was inebriated or otherwise impaired, and attempted to deal with the situation in that manner, take her to the Durham Access Center. When she was at the Durham Access Center, she reported that she had been the victim of sexual assault. At that point, she was transported to Duke Hospital for examination, was seen by a sane nurse, Tara Levesey, at that location. That Ms. Levesey and Dr. Manley, I believe, had examined her, that there were findings, both physical findings and, I guess, emotional state findings that were consistent with the story of sexual assault. And that was pretty much it with respect to that night. They did not actually return to the residence with a search warrant until the 16th.
You've heard testimony from Detective Hyman previously that you made a statement to the effect of, "We're effed" at some point in time. Was that at that meeting?
No, sir. That was. I do recall the instant where that took place. It was later that week. It was not at the first meeting. And as they brought me more material, it became clear that one of the issues in the case was that Officer Shelton, the first officer on the scene, had not immediately understood that there was a sexual assault taking place, which was not necessarily his fault, but that his actions thereafter were reflective of an attitude that didn't take into account that might have occurred. My experience in sexual assault cases in particular is that the attitude of the first officer on the scene is important in establishing the baseline of facts for the case, because he's often going to be talking to someone who has just been traumatized, has been through something very difficult, and might be having trouble communicating precisely what happens. And so to the extent that the communications are further hampered by the fact that he doesn't understand that something has taken place, or maybe doesn't believe that he's dealing with a rape, but believes that he's dealing with an intoxicated person, that can be reflected in how carefully he takes down what is said and how closely it reflects what was actually told to him. In addition, the standard protocol for sexual assault kits does not include either a liquid blood sample or a urine sample. So when there came a question later with respect to whether or not there might be the use of a drug in this case or some type of question of impairment, we didn't have anything from which that could be established because that hadn't been looked at initially. And so we were kind of starting off in the hole because there were a lot of things that, had they been done initially, we might have been able to get more evidence early on that we now might not have the opportunity to get. So we had to come up with alternate strategies for trying to deal with that because the best methods were no longer available to us.
I'd like to have you, if you would, please, where in the week of March 27th do you think that situation you just talked about, where you made that comment, where was that in the course of that week?
I don't know specifically. I'd guess probably, if I had to pick a day, I'd say most likely Thursday.
From Monday through Thursday, do you recall what your involvement might have been on the case at that time?
Well, the first thing, of course, that happened is shortly after the briefing, the media began to come to my office, local television stations and newspapers. I don't recall everybody who came, but there were some people who started coming, I think, early afternoon. And they were asking me about the non-testimonial order, and I attempted to restrict my comments to them to the matters contained in the public record. But it was fairly clear on that day that there was some of the interest that I had anticipated.
Let me stop you right there. I believe you previously testified that one of the reasons you thought it was important to be involved in the case because it would garner significant media attention. Is that right?
Yes, sir.
Could you explain to the panel what you meant by that, why that was important to you?
Well, Durham is a very diverse community. It is a community that prides itself, I believe, on being progressive in many matters, and things that are said that have racial connotations maybe carry more weight in the Durham community than they might in some other communities, just in the way things look at them. My concern, which kind of came about, was that based on the allegations that were made and the identities of the people who were involved, that this might be something that would press some of those buttons.
If you could, walk me through on a two-track level, if you could. First, finish up what steps you believe you had in relation to the investigation for the week of the 27th through April 4th.
I'm sorry, I'm not sure I understood your question.
I went back and asked what you did from Monday the 27th up till Thursday. Did you have any involvement with the investigative process from that Monday until that Thursday? Or was your involvement in the case more related to the media at that time?
Well, there was some of both, because sometimes I would be asked a question by a media consultant that I would not know the answer to, and so I would not comment, but then I would ask the investigators, what about this? One that comes to mind is I remember being asked in some interview if I believed that the call that had caused an officer to go to that house was a legitimate 911 call or was one that was made up. And I had no idea. That was not something that had ever been discussed. And so at some point after that, I asked one of the officers, and they told me that they did believe that that call had been made by the other driver, the other dancer.
Let me ask this. From March 27th up to April 4th, was it the Durham Police Department that was in charge of the investigation, or was it the Durham DA's office that was in charge?
It was the Durham Police Department. As a matter of fact, on Tuesday morning, which would have been the 28th of March, Mr. Robert Ekstrand, who's a Durham attorney who had apparently appeared with the players at the time that the non-testimonial was executed and indicated that he represented them, came to my office. And I thought that this would be an opportunity for me to talk to him about the case and about any information that he might have. He actually had come to ask me what I intended to do with the case. And I told him that the case was still under investigation, that I knew that the police department was attempting to contact, to talk with the players that were involved or might have been involved in the party to see what they knew about that. At that point, to my knowledge, the only people that had actually talked to the police were the 3 residents of that address. And I told Mr. Ekstrand that if any of his clients wished to speak to the police, we would love to hear what they had to say, that he probably needed to go to the police and have them talk directly to them, because I really didn't have enough information about the case at that point that I felt that I would be able to ask the right questions. And so I asked him if he would go to the police with any information that he had. Mr. Ekstrand didn't answer directly, but the impression that I had was that he wasn't going to do that.
Did you learn whether any of the people that he represented ever made voluntary statements to the police?
As far as I know, none of them did.
What do you remember? You talked to the media for a period of time at the beginning of this case, a lot, didn't you?
Yes, sir. And I believe that it might have been, of course, the initial information or the initial media interest was based on the non-testimonial order itself. At some point, and I think it was that same day, Tuesday afternoon, I wanted to let the public know a couple of things. One was that the case was a case that was being looked at very carefully by somebody who would try to take the interest of the community at heart, that being the elected district attorney. And the second thing was that we were appealing for any information from people that might know something about the case. I wanted people to come forward. It was our belief after this initial incident that, well, if I could back up just a second, one of the things that really struck us about this case as being very much different from any other incident involving a Duke party that we had seen was that normally when there was a call for police to go to a party in the vicinity of the Duke campus where there's either drinking or loud music or noise or something like that, is that when the police arrive, the party is still going on. And that's the normal scene that we see. In this case, after the call came in, I believe that it was less than 5 minutes before the first officer arrived at the scene, and there was nobody at the scene. There was evidence that a party had taken place, but even the residents of the house were not there. And we felt that was very unusual. It was my belief that what had happened was that everybody had said had been told to evacuate the house immediately, and that probably a lot of people who were at the house had no idea what had happened, if anything had happened or anything like that. And so we were hoping that some of the people who might have been at the party, who would not have had anything to do with any activity that was of the nature alleged in the non-testimonial order, would come forward to tell us what they knew, either to clear their names or to let us know that something did not happen, whatever was the case. But we hope that we had no reason to suspect that most of the people at that party had any involvement in what had allegedly taken place in the bathroom.
Do you recall making statements to the media in the early part of this case about the players' wall of silencers or something to that effect?
Yes, sir, I do. And
do you recall making statements about if they didn't do anything, why do they need a lawyer?
Yes, sir, I did.
And other matters about them exercising their right not to testify. Do you remember making those statements?
I'm not sure specifically about testifying, but I did make statements to that effect, yes, sir.
And are those statements you would have been able to make to a jury?
No, sir, they're not.
Did you think through that process before you made those statements back in the beginning of March?
Clearly not as much as I should have. I mean, I was certainly not intending or attempting to make improper statements. But I think clearly some of the statements that I made were improper.
Were violations of the rules of professional conduct?
I would have to say so at this time, yes, sir.
Did you have any thought process back when you were making the statements to the news media in the latter part of March, early part of April, as to what effect that could have on damaging any subsequent prosecution and the accused's rights to a fair trial?
At that point, we had, no suspects, no one had been identified, and so I was hoping to get information that would enable us to identify some suspects. I think that, during this period of time, I did not actually see the broadcast of many, if any, of these statements for a number of reasons. The primary reason being that during this period of time, I was also involved in a political campaign, so that when I left the office, I would normally be going to some sort of function or meeting or something that had to do with that. Very rarely saw television coverage. I saw, for instance, a clip earlier this week that I had not seen before. It made me cringe.
You made it cringe? Did you think it was improper?
Yes. I mean, it did not come across at all like what I was trying to do. And, maybe if I had seen some of those things, I would shut up sooner. But my intention at the time that I was making those comments was to maybe make someone who did have information about this that could help us with the investigation feel a sense of duty to come forward. That was what I was really trying to do, was to get people to cooperate with the law enforcement investigation.
And you made multiple statements which might have had you talking about the racial aspects of this case back during that period of time, didn't you?
Yes, sir, I did.
Do you believe that those statements were proper?
I would have to say in balance that I do not.
And why were you making those statements?
Because of the nature of the allegation and the identities of the parties that were involved, there was almost immediately an outcry, well, I'd say actually two outcries within the community. There were people that were saying somebody needs to be put in jail. If this were, one of the most quoted comments was, if these were members of a North Carolina Central team, they would already all be in jail. So I had that sentiment being expressed on one side. On the other side, I had a sentiment that could best be expressed by people who are strippers or exotic dancers by reputation, are not people that can be raped and that would not be sexually assaulted by people like the Duke Lacrosse team. And what I was trying to do was keep anybody from making decisions based on either of those points of view.
You mentioned that you didn't have an opportunity to view the tape because you were involved in an election campaign. Is that correct?
That's why I didn't see anything initially.
Okay.
And the reason that I never watched anything after that was I was tired of hearing about it.
And you saw the tape that was played yesterday where you were at the candidates forum. Is that right?
Yes, sir, I did.
And the issue of race came up in that tape too, didn't it?
It did.
And do you think that was appropriate?
No, sir.
Why'd you do it?
I believed it to be a part of an honest answer to a question, but I think that in viewing that, and of course I was at the forum, I'd never seen a tape of the forum, I think that crossed the line to make a comment about what Durham looked like in the eyes of the world. I thought that many of the comments I made were appropriate. The fact that we believe that most of the people of the party were not guilty of any crime, and we needed to establish that, to remove that shadow as well. But the comment about race was not a comment that should have been made.
You made what effect did the fact that you were in a political campaign have on the way that you approached the Duke lacrosse case?
My fervent desire was to keep the Duke lacrosse case from either being affected by politics or affecting politics in Durham. That is, I did not want the decisions in the case to be based on politics. I didn't want the political climate to be based on the case.
You also made statements to the media during the early period of time in this case about the fact that you may charge other individuals that were at the location as aiders and abettors, and that the stone wall of silence may come crumbling down when that occurred. Do you recall that?
I recall both of the comments in general. I recall that the first part of that comment about aiders and abettors came up in response to a question from a reporter. He was asking me if I expected to charge people as aiders and abettors. And I explained to her the best I could what the law about aiding and abetting was in North Carolina, that mere presence was not enough to constitute aiding and abetting under most circumstances, that if there were a special relationship, it might be the case. I gave kind of a textbook definition that took 5 or 6 minutes, and the only thing that got recorded was I said that some people might be charged. And that was kind of a lesson, an early lesson, and what I said to a reporter not necessarily being fully reported. So I did make a statement about that. My understanding of the statement I made was not that we were likely to charge anybody, but why we likely would not be able to charge anybody unless we had specific evidence. That's not the way it came out. After that, I was asked about specifically the fact that people were not commenting, and I said that if we made arrests, that might change that. I wasn't referring specifically to aiders and abettors. I was referring, I believe, to people who were involved directly with the offense.
Excuse me, what was the last part of that? I didn't hear.
I think that my stonewall of silence comment was directed more generally to the whole question of anybody getting arrested in the case at all, as opposed to specifically charging aiders and abettors.
You also made some comments, and these are all a lot of these are in stipulated facts.
Yes, sir.
Entered into multiple stipulations in this case. Is that correct?
Absolutely.
And of those stipulated facts, you also made comments about the use or non-use of a condom in relation to a sexual assault. What do you recall about that?
Well, a couple of things. The first thing that I would say is that with respect to that, I believe that I was responding to a hypothetical question. That is, are there reasons that DNA evidence might not be found? And of course, there are many reasons that DNA evidence might not be found. And the one that I said, certainly, one example would be if a condom were used, we wouldn't expect DNA to be found. I could have also said something like, if an ejaculation didn't take place, we might not expect it to be found. Or I could have said, if there was no assault, we might expect it to be found. There are many things that could have happened. I chose that one hypothetically, and that was taken as my indication that condoms were used, which was never what I intended to say.
But at the time you made that statement, you had in your possession information from the same nurse in this case, didn't you?
Yes, sir. I had seen the same nurse's report, and I knew that it was checked that condoms were not used specifically in this case.
And you still made the analogy with the condom?
As I indicated, I made the analogy with the condom because I thought I was responding to a hypothetical question, and that was probably an unfortunate choice. I would say, in addition, that I thought that unprotected sex under these circumstances was not a high likelihood. That's just a personal opinion based on the circumstances under which this assault allegedly took place, the people who were involved, the identities of the people who were involved. It's been my experience in other cases that victims are not always sure about whether condoms were used, but I always thought that it was unlikely that there would be unprotected sex in this case.
Prior to getting involved in this case, had you ever been involved personally with a case that garnered national media attention where you had to deal with media sources from all over the country?
Not me personally. The office had been involved in a case similar to that. Well, it turned out not to be nearly as significant as this one in terms of media attention. But we had a case I believe it was tried in 2003, so I'm not sure. Maybe it took place end of 2001 or something like that, involving Michael Peterson. And that case did garner significant media attention. I was involved in the case early on in kind of an advisory capacity, but primarily during that case, my responsibility was to run the office.
And in those duties and responsibilities, you weren't dealing with the national press and making statements?
Well, I wasn't. Plus, in that case, very early on, the judge in that case had issued a gag order and had forbidden anybody to discuss any of the case. So there were no comments were being made, but it was pursuant to that gag order.
At some point in the early portion of this case, did you attempt to limit your comments to the media?
Do you mean the scope of the comments or the
just involvement with the media on making comments? What period of time do you believe you were talking to the media on the first part of this case?
The 98% of the comments that I made to the media about the case were in the period from March the 27th to the morning. I think I had an interview that was scheduled the morning of April 3rd that was scheduled before I said we're not going to schedule any more interviews. I had essentially quit by the end of that week, but I did indicate I think I had one more on April the 3rd. I had also attempted to limit my comments to the press to matters in the public record, although I think that sometimes I got off that, either because I got confused about what was in the public record or maybe got carried away a little bit. But at any rate, it became clear by the end of that week, by the end of the week of March 27th, that my comments trying to get somebody to come forward had not had any effect.
Do you think that your comments during that week of the 27th, April 3rd, increased the media attention on it?
Well, it's certainly possible. I think that the media attention would have been tremendous anyway, but I guess if they hadn't had somebody who was willing to talk to them, they might not have spent as much time. I mean, obviously the media hasn't been talking to me very much since then, but they're still involved in the case. So it's certainly possible that that was the case.
Did you intend for your statements to have that effect?
No, sir. It was not my intention to do anything other than try to get the case resolved quickly and to not get anybody to do anything rash based on assumptions about what might have happened.
Do you acknowledge that as a result of making many of the statements that you made to the media in this case, that this panel will find that there were violations of the rules of professional conduct that will get us to the second phase in this case?
Yes, sir. With respect to the media statements, I do.
Okay. Let's move forward to the results of your work with the investigation. And let's talk a little bit, if I could, about a meeting that you had with Sergeant Gottlieb and I believe Detective Hyman. Well, let me back up for a second. Do you know when Detective Hyman became a detective in this case?
Only from his testimony.
You didn't know that at the time?
I didn't. Well, I knew that he'd been involved in this case pretty much since the outset, but in terms of the exact date, I don't know that I knew that. I knew that investigators, well, the whole...
Strike that question. I mean, what I'm trying to ask you is, do you know how long Detective Hyman had been a detective as opposed to a patrol officer?
I'm sorry, I misunderstood your question. No, sir, I did not. I did not know Detective Hyman before this case.
And had you had any dealings with Sergeant Gottlieb before this case?
I had some dealings with him, and some of them actually had involved, encounters that had taken place in this same neighborhood. I'd known Mark. I think Mark had been with the department and had left and had come back at some point. But I had actually been familiar with him for a long time. I didn't know him that well because I don't think, for instance, that I ever tried a case where he was a witness before this time.
At some point in time, and if you need to refer to the officer's notes, which would be their Exhibit 202 or 204, did you have... Strike that one more time. Were you aware prior to April 4th that there had been various photo arrays that had been submitted to the victims in this matter?
Yes, sir. I think that I became probably aware of that on the 27th. Certainly it would have been the 27th or the 28th that I was told about that.
And what were you told about whether or not the victim was able to identify any suspects in the initial photo arrays that were done?
I was told that nobody had been identified. I was also told the circumstances under which those identifications had been attempted. I don't know if you want me to go into that or not.
That'd be fine.
Initially, the victim had indicated that the assailants referred to themselves by the names of Adam, Brett, and... Matt, thank you. I was going to say Mark, I knew that wasn't right. Adam, Brett, and Matt. And so in attempting to come up with a lineup, they looked for people whose names were either those names or something similar to those names that might have been understood. The only photographs that they had available were apparently team photographs that they obtained from the Duke website, which one of the officers said, and I don't remember which officer said, basically they all looked alike to them. That is, that they had trouble distinguishing some of the pictures from each other. They put some of these photographs containing an Adam or a Brett or a Matt in lineups and presented them to Miss Mangum under circumstances that they described as less than ideal. That is, the room in which she was sitting was in her home. The room was not particularly well lighted. There were other people that were coming and going, so there were distractions. And said that also that she appeared to be in quite a bit of physical discomfort at the time that they were presenting the photographic lineup. She was not able to give them any real identifications and seemed to have enough difficulty with the procedure that they just decided not to go any further with it.
How many different photo arrays were you aware of that were presented to Ms. Mangum prior to April 4th, 2006?
I'm not sure what you mean by arrays. I think that there were 2 occasions that they attempted to show her photographs, but I don't know like how many panels of photographs they showed altogether.
Okay. But you knew of whatever number that they submitted that she was unable to identify any suspects?
Yes, sir.
At some point in time prior to April 4th, 2006, did you have a conversation with Sergeant Gottlieb and Detective Hyman about the status of the investigation and what ultimately is the photo presentation to the victim that occurred on April 4th?
Yes, sir. We did have a discussion about that. I'm not certain of the exact date. My guess is it was the previous week, but I don't know for sure. The reason, of course, or one of the reasons for the non-testimonial identification order was to obtain photographs of the lacrosse players that would show more how they looked at a close proximity to the time when the incident took place. So that's why those photographs in particular were obtained. After the photographs were obtained, we were dealing, of course, with the initial media circus involving this, and so I said, let's not don't go do anything until we've talked about it. We were hoping during that week that someone would come forward and would give us information about the case. Certainly, that didn't happen. And then we were left with a situation where we had no suspects. We did not know for sure who was at the party. We did not know if the people at the party were restricted only to lacrosse team members, which was what we were told. We later found out there were some non-lacrosse players there. So what we decided that we would do is try to determine if there were anybody that she could direct us to that was at the party that she might have had some interactions with, so that we could go directly to that person, through his attorney, of course, and say, we understand that you were at the party and that this took place. Would you be willing to talk to us about it? My experience, and I imagine that of the law enforcement officers, is that if you walk up to somebody and say, do you know anything about this incident, you're a lot less likely to get a response. And if you go up and say, I understand that you were involved in this incident and this is what you did, you want to talk to me about it. So we were hoping that if we could identify specific individuals that might have had some interaction in this case, that would help our investigation go along. That we might talk with somebody who, for whatever reason, had not come forward previously, would give us information that would further our investigation.
And so what was the procedure that you discussed with Sergeant Gottlieb and Detective Hyman? How'd the conversation go about what procedure you were going to follow, which ultimately resulted in a presentation to the victim on April 4th, 2006?
I told them that I would like for her to have an opportunity to see all the photographs, but not in the way that they had been presented previously, which I believe was in displays of 6 or 8 photographs. That we wanted to do it differently and just ask her to look at the photograph and see if it was somebody that she recognized as having been at the party, and if so, did she remember what that person was doing, so that we could determine if there was any kind of interaction that we might be able to follow up on. Because of all the attention that the case was receiving, and I just felt that whatever we did in this case, we were going to need to be able to justify later on. And so I said we need to be able to show whatever procedure we do to let her determine who was at the party in such a way that anybody who looked at that later on would be able to see what we did and not just have to take our word on we did it this way or we did it that way, because this is something that might eventually lead. This case may eventually be in court, and anything that we do, in the course of the investigation, we need to document. The actual idea to do it as a PowerPoint, I believe, was Detective Gottlieb's idea. He indicated that he could set that up so that he could present each of the photographs sequentially, and the victim could see the photographs. And I said that I would like for it to be done in such a way that a person, I told him that I wanted that procedure, whatever the procedure was, recorded, so that somebody could come by afterwards and actually see the procedure itself. And I also said that I would like for it to be done, if possible, in such a way that we could both see whatever photograph Miss Mangum was looking at, but also see her face as she was looking at the photograph, so we could see if there was any kind of a reaction. And the procedure that he came up with, I believe, was to have her look at a screen, have a camera focused on her from the side, and also showing another screen so you could see the photograph she was looking at.
And was that the way that the procedure was actually set up by Sergeant Gottlieb that was performed on April 4th, 2006?
I believe that is correct.
And as a result of that, well, tell me what you understood Miss Mangum did as far as identifying people that were at the party.
Well, my recollection is that the majority of people that she was showing pictures of, she did not recognize. With respect to some people, she said, well, an example would be Dan Flannery. She said this is the guy who gave me the money. And, of course, that was consistent with Mr. Flannery's statement that he was the one who had paid her when she arrived at the party. There were, I believe, four photographs altogether that she said other things about, other than somebody being in the bedroom or mixing a drink or whatever of the people that she actually identified. One of those people, she said, this looks kind of like one of the guys who assaulted me, but did not identify him as that person, just said that he looked like one of the guys who had assaulted her. Obviously, once we started the procedure, we didn't want to stop it right after she'd done something because we didn't want to add any emphasis to that. So they were supposed to show her all the photographs all the way through, regardless of what was said. With respect to two photographs, Mr. Finnerty and Mr. Seligman, she said, this is one of the people that assaulted me, and described the role in the assault. I believe that with respect to Mr. Finnerty, she showed some emotional response to that one as well. With the photograph of Mr. Evans, she indicated that he looked like one of the people that assaulted her, except for the person had a mustache. She indicated that the person that she believed him to be was the person who would have grabbed her from behind, the one whom she would have been struggling with when she broke her fingernails off. She was only able to say to a 90% certainty that he was her assailant.
Did you, in your initial investigation, ask Detective Hyman whether he thought that the victims was believable?
Yes. Both Investigator Hyman and Sergeant Gottlieb indicated to me that she seemed very believable to them. And, of course, subsequently I spoke with Tara Levesey, and she indicated the same thing to me. Once individuals were identified as suspects on April 4th, 2006, strike that question. At the time that photo presentation was going forward, had the Durham PD already sent off certain items to the SBI lab to be tested? Yes, sir. They had sent off, I guess, the items that were taken pursuant to the order, the non-testimonial order, were sent along with rape kit items probably in that same week. And did you hear Agent Lynn testify that she had a phone conversation with you, I believe, on March 30th about the results of those tests? I did speak with Agent Lane. I don't recall the exact date. I do know that she has a telephone log with respect to that, and she did tell me what she had done and what other tests were being done. I had several conversations during that week with various members of the office, SBI. Some of them were individual. I think a couple of them might have been conference calls. And when did you ultimately receive the report from the SBI related to those tests that were performed? We received SBI reports, of course, over a period of time, but my recollection is that with respect to the specific testing of the samples that were taken from the players, we had all of those reports by April the 10th. And what did you do with those reports? As soon as we got those reports, we had a list of attorneys and players. Miss Candy Clark, who's my administrative assistant, had that task. And once we got the reports, we made a copy for every one of those players and put them in envelopes. There were some attorneys who represented more than one player, and so we might put multiple copies in that envelope. We had an envelope with each attorney's name on it, and then the names of the players represented, is my recollection. And she made calls to their office so they could come and pick them up. Did you, prior to the time you received those reports, did you learn through conversations with agents at the FBI as of the results of their tests? I certainly learned of results as the tests were going on, but I was also aware that there were other tests being conducted. For instance, if someone would call me, then that person might say, this is what I've done and this is what I have gotten. It's now in certain other places being tested under different tests by different agent or whatever.
And going back to those tests were performed on items those tests were performed on items that were obtained from the players through the non-testimonial identification order. Is that right?
Yes, sir.
And that order was issued, its statutory authority is 15A-282, is that right?
Yes, sir. That's correct.
What was your understanding back in March, early April of 2006 as to your duties to provide the reports from those tests to either the individuals or their counsel?
My understanding was that I was required to provide reports as soon as those reports were received. My practice had always been to provide reports when I received the written report. I have heard testimony to the effect that since the statute does not say written report, that it means we have to give the results as soon as we receive them. That is not something that I have ever done, and I don't know if that has ever been the practice in my office, although I haven't asked specifically. But my personal practice in response to that has always been to provide the reports when the written reports were received. Now, this obviously is the first time, as I indicated, that I had more than one person that I had to provide the reports to. So it's never been a particularly laborious task in the past to provide anything.
How was it that it came about that you transferred the information from the SBI lab to an outside lab for further testing?
At some point during the SBI testing, I had a telephone call from Mike Budzinski, who I believe was the director of that particular section of the lab. And he indicated to me that although the tests done by the SBI had not shown any definitive results with respect to DNA on any of the samples, other than there are a few specifics, the towels that are involved, but certainly not with the rape kit. He said that there were some items that they tested that showed evidence of a mixture of DNA, where the predominant contributor to the mixture was Miss Mangum, and that there was other DNA that they could not separate out. And he indicated that mixture might be able to be resolved through something that I had never heard of before called YSTR testing. And we talked about that. He told me that was a procedure whereby the cells containing a Y chromosome, which must have been contributed by males, were separated out, and then DNA tests were run on those cells. He indicated that the SBI lab did not do that kind of testing, but provided me with a list of maybe 4 or 5 labs that did, and suggested that I could call them and maybe come up with something, a lab that could do that. I believe that I called a couple of labs myself. Some of the officers were calling labs. We needed to know how much the testing would cost, how long the results would take, things of that nature. And I believe that we felt that of the people who could do the work, DNA Security, Inc. Was probably our best choice in terms of how long it would take and how much cost it would be done for.
Let me back up. One other question about the SBI. There was testimony from Agent Lane that there was a rush that was put on that testing. Who requested that rush?
The district attorney's office requested. I requested that. I don't know if I communicated the request specifically, but my office requested that.
Why is that?
We felt that because of the the time in the school year, that we were getting close to the end of the school year, that most of the people that we had sought samples from were not even from the state of North Carolina, much less from Durham, and that it would be very difficult for us to complete our investigation, once school let out for the year. So we were trying to get as much information as we could as quickly as possible.
All right. Back to the DNA securities issue. Were you the person that initially contacted that lab, or do you know whether it was law enforcement?
I believe it was law enforcement. I think it was Michelle Soucy, but I'm not certain about that.
And there was ultimately an order that transferred the information to that lab. Is that right?
Yes, sir.
All right. I think if you go to Exhibit 207, there's a petition and there's an order.
Yes, sir.
First off, why did you need an order to transfer that information to an outside lab?
Well, we had somebody had to pay for the testing, and so we had to get the court to approve the whole process of allowing an outside lab to test and then us paying for that investigation. So that was something that we needed the court's permission to do.
And do you know who actually drafted the petition and order related to the testing that was performed by DNA Securities?
I do not know who drafted the order. The petition was drafted by David Sachs in my office at my request. Certainly the usual practice for the court is to have the person who is granted the relief draft the order as well. I don't know if Judge Stevens, since I never spoke with him about this, I don't know if he directed what was contained in that order or if that was an order that was prepared by Mr. Sachs who signed.
Why did Mr. Sachs prepare the petition rather than you?
I do not recall at this time why I couldn't do it, but I was involved in something else and I asked him to do it for me.
What do you recall telling him that you wanted him to put in the petition?
I'm not certain. I may very well have drafted some points that needed to be included based on my conversations with Dr. Meehan, but I'm not certain if I did that or not.
As far as the language that was discussed, and I believe the chair of the panel outlined related to the motion that I made, what sort of instructions did you give to limit the testing that was performed by this outside laboratory before you left so that Mr. Sachs would do it?
I gave no instructions. As a matter of fact, I didn't even notice that limitation in the order. The first time that I realized that they didn't have all the samples, let me back up a second and say that the main reason that we were sending this was to resolve the mixtures which were contained in the fingernail and I think some other swabs, but particularly the fingernails we were interested in. The first time that I spoke to Dr. Meehan, they hadn't even received the fingernails. And I didn't know why that was, because that was my greatest interest was in having those fingernails tested. And so I talked to the officers and we arranged to get that over there. It was actually not until during the course of the proceeding that I realized that the order had specified just the items in the rape kit.
You mentioned your first discussion with Dr. Meehan. Was that a face-to-face discussion or was that a phone discussion?
My recollection is that my first discussion with him was in person, but I'm not certain about that.
You've heard testimony here from the officer, Dr. Meehan, about 3 different meetings that you had with Dr. Meehan.
Yes, sir, I have.
What did you tell the grievance committee and what did you state in your answer as to the number of meetings that you thought you had with Dr. Meehan?
My personal recollection is that I only had 2 meetings. I could only recall 2 specific times that I went to Burlington and sat down with Dr. Meehan. I knew that one of those meetings was May the 12th because that's when we picked up the order. The report. The other meeting that I actually had one meeting listed on my calendar, and that was the one on April the 21st. My calendar lists all the things that I know about before I do them. That is, if I schedule an appointment with somebody, I'll write it on the calendar. If I'm supposed to do something at a particular time, I'll write it on the calendar. It doesn't mean that there aren't other things that I do during the day. It's just that if somebody just comes in, there probably won't be a calendar notation for that. So there was notation on my calendar for April the 10th. There was for April the 21st. My personal recollection was that I had only 2 meetings. So I believe that those meetings took place on April the 21st and May the 12th. Having heard the testimony of the other people, I'm not asserting that there was not a third meeting or that I was not present at the April 10th meeting. The problem for me is that looking at it as 2 meetings, what I remember is the first meeting and the second meeting. And that would mean that if there were 3 meetings, then I have probably ascribed certain things to one of those other meetings when they might not have taken place in that meeting. It is, if I say the first meeting, I can probably, if I remember something definitely occurred on the first meeting, then it is most likely that occurred on April the 10th, as opposed to April 21st.
As it relates to any meetings that you had with Dr. Meehan, in each one of those meetings, did you all discuss the fact that the testing done by his laboratory found male DNA evidence on certain items of the rape kit that were not consistent with any of the reference samples supplied by the 46 Duke lacrosse players?
That was something that came up during the course of the first meeting, which I now assume is the April 10th meeting.
Did that also come up at any subsequent meetings that you had with Dr. Meehan?
In one context, obviously, in terms of explaining what happened at the meeting, the first time that we went, of course, we were introduced to Dr. Meehan. He took us very briefly through the lab. We sat down and spoke with him, and as he indicated, the first thing he was going to do was try to give us a primer on the use of YSTR testing, how it worked, why it worked, what it could do, what the limits were, things of that nature. And so he described these things for me, and in the course of doing that, he showed us some of the electropherograms that he prepared in the case. At that point, he was just showing them for illustrative purposes, that is, to show this is how this would chart, and this is how you'd read this chart, and things of that nature. During the course of that, he said that they had examined all the items from the rape kit. I don't know that those were his exact words, but those were the items he's referring to. And he said in the course of doing that, they had not found any DNA from any of the 46 samples that had been submitted to them, which would be the Duke lacrosse players, but that they had found male DNA that did not match any of those samples. And, of course, in the course of this, we talked about all this. We were interested in what that meant. So we talked about things about how DNA might get transferred, the types of activity that might cause transfer, types of activity that might not cause transfer. We talked about the fact that it could not be determined from the finding of the DNA where it had come from, how long it had been there, whether it had been moved from one place to another or anything like that, just that it was present. If I could say one other thing, to put this in context, after the SBI had done their DNA testing, we knew that this did not involve what I would call an ejaculatory event. That is, there was no evidence that there was any semen or sperm on any of the samples. And so at that point, we were not looking for any evidence that would show that there was ejaculation involved with the incident that took place on March 13th, March 14th, based on that. Now, when I say ejaculation onto the body of Miss Mangum. So,
Go ahead.
I'm sorry.
Continue with your answer.
Okay. So, as I indicated, my biggest concern was whether or not some of these mixtures could be resolved, but we had expected that he was going to re-examine all the evidence to find out what it said, and also, of course, it also served as kind of a test for the SBI. And one thing he said was that he was able to confirm all the things that the SBI had said in terms of his testing. So when he said that there was other YSTR data, so that would have to come from male DNA present. We talked about it. He said there was only one complete profile that he could get from that, and he suspected that, I believe that came from a vaginal swab sperm fraction. He said that although no sperm or semen had been identified, that he suspected that most likely came from old sperm, by which he meant more than 3 days old. That there had been a sufficient quantity and it was sufficiently recent that it hadn't degraded to the point they couldn't identify DNA material, but he couldn't say anything other than the fact that it was at least 3 days old about its origin. So we knew that would not have had any involvement with this particular incident, and we also knew that she had claimed to have had intercourse with her boyfriend during this previous period of time. The remaining genetic material, was insufficient to generate full profiles. Dr. Meehan said that normally if you have 2 or 3 cells, you can generate an entire profile. So if you have fewer than 2 or 3 cells, it means that you're working with less genetic material than that, either a cell or even less than a cell. We talked about how there could be a transfer of such items. And one thing that we asked him specifically, even though they hadn't tested the fingernails yet, we knew that the fingernails had been found in a trash can in the bathroom, and it was not unreasonable to suspect that other things that might contain DNA had been thrown into that trash can. So one thing we asked him was, if you have something that is lying in a trash can and you put something else, tissue or something like that, in the trash can, is it likely that just by being in proximity there will be a transfer? He said that he would not expect, for instance, if you blew your nose and threw the tissue in the trash can, that there would be a transfer of DNA in that manner. We talked about the fact that, I think he used the example of a pen. He said that if you pick up a pen and, from say you pick it up and set it back down, that you would not expect to either put any DNA on that pen or to get any DNA off that pen. But that if you were to have, contact between a surface that contained DNA and a body part or something that was kind of a grinding, like if you, turned your hand like that, or perhaps if you were sitting on something and like in this chair and you turn like that, that is the kind of activity that might lead to the transfer. But that nothing really could be said about precisely how the transfer took place or when the transfer took place. So it was not that I considered this insignificant, because clearly it was significant in terms of explaining or understanding how all this played out in describing the whole process to a jury. But it did not seem to me, from my conversation with Dr. Meehan, that this evidence had anything specifically to do with what they were doing the test on. And so, it was not something that I paid a whole lot of attention to other than understanding the general thing. We had assumed that the match to what he said was the old sperm would most likely be boyfriend. That did turn out to be the case. And that, by the way, was one of the times subsequently when we discussed this in the sense that he confirmed that was the case. I knew that there were other samples that were to be submitted that could be tested. I did not know. I knew they did not have everything. So I looked at this as a preliminary result that really didn't have a whole lot to do with the purpose of testing. Now, that having been said, I want to make it clear right now that certainly is something that the defense attorneys were entitled to have. I mean, I don't want...
Would you repeat that for Mr. Tyler?
That is certainly evidence that the defense attorneys were entitled to have. It was a finding that he made, a scientific finding. There is no question. Whether you view it as exculpatory or not, I'm not denying that they were entitled to have that evidence. I did not view it as exculpatory at that time, but that had nothing to do with my providing it or not. They were entitled to have that evidence.
Mr. Nifong.
I wasn't sure how long I was supposed to go on answer with no questions, so I hope there's stops.
Let's go on and just talk about your recollections of any conversations that you had with Dr. Meehan about the report and reporting of his findings and his tests.
Again, it's going to be hard for me to say specifically when this took place because I only remember 2 meetings, and this did not take place at the first meeting, to my knowledge. It did not take place at the last meeting, to my knowledge, would be what I'd say, because he was about the report. But I can't say if this took place on April the 10th or April 21st. My suspicion, or my best guess, if I had to fit my memory of 2 meetings into 3 actual events, is that it most likely took place on the 21st, but it is possible it took place on the 10th. Dr. Meehan's concern was, and this is one reason I believe that it happened on most likely on the 21st. His concern was that he knew that whatever report was generated was going to be going to every one of the people from whom we got samples, because I told him that. By the way, the report that he said that I needed was my report to respond to 15A-282. He said a court proceeding, but specifically what I needed the report for was to give to the attorneys in reference to my duties under 15A-282. And he said that he had concerns about producing the entire DNA profiles of each of these players because he had concerns that, and I think it was probably based on what happened with the SBI reports, that there was going to be some public dissemination of that material. He thought that would not be in the best interest of the people whose genetic profiles those were. And this is the only discussion that I recall having had about what went in the report at all. But I told him that, my recollection is I asked him, have you seen the SBI report? And he said that he had. And I said, well, I need something like that. You know, what items you tested, what tests you performed, and what the results were. I said, you don't have to include the profiles because they're part of the underlying evidence that you use to make the test, to conduct the test. They're part of the underlying data and may very well have to be furnished later if this case gets to that stage. But that right now we're looking for a report that will put the people entitled to receive it on notice of what tests you conducted on their samples and what the results were. That's the only conversation that I recall having had with him specifically about what went in the report. I'd never been asked before by a lab, you know, what the report needed to contain. Before that, with one exception, I dealt with the SBI lab, and they wouldn't have asked that. So I really didn't know what to say, which is why I asked him if he'd seen the SBI report and used that as a kind of an example, because I didn't know what the answer should be.
Did you ultimately meet with Dr. Meehan on May 12th and go over the report that he had prepared?
We did. We had been hoping to get the report that week, and there had been some telephone calls made. I'm not sure if I made them or if somebody else did, but our understanding was that the report would be available early afternoon on the 12th. And so we went over on that date. There is, again, in trying to divide the information in two meetings that I recall over the course of 3 meetings, I remember that on the date that we learned that a DNA match had been made to one of the fingernails, which I knew did not happen at the first meeting because he did not have that evidence at the first meeting. So I'd attributed it to the second meeting, which is, I believe, to be May the 12th. But now I believe the second meeting was most likely the April 21st meeting. That we had gone because the information I got, and I don't remember it being directly from Dr. Meehan as he testified. I believe that I got it from Mark Gottlieb, but at any rate, somebody had called me and said, we got some results that we'd like to talk with you about. So we did go over there on that date, and we sat down, and Dr. Meehan told us that he had tested the fingernails and that he was able to identify one of the lacrosse players in the mixture that was taken from the fingernails that were found in the trash can. And I said, David Evans. And he looked at me kind of surprised. And because we'd never discussed the fact that the evidence up to that point against Mr. Evans was that Ms. Mangum had identified him to a 90% level of certainty as a person that she was struggling with when the fingernails were broken off. But he confirmed that it was, Mr. Evans that appeared to be showing up. My recollection is that he either had not tested or had not come up with the match yet on the unused fingernail, which was probably taken from the makeup bag, the one that was found on the computer tower, that matched to another lacrosse player. We didn't believe that had much to do with the events of that night under any circumstances. But, and that's really what I remember about that particular situation. I had attributed that to the May 12th meeting, but I believe that looking at how all this must have fit together, that likely happened at the April 21st meeting. So at the May 12th meeting, when we went in, he would have presented us with the report and would have gone over the report with us. But I don't recall, except for the first meeting, I don't recall any of these meetings being particularly long. The first meeting that we had was kind of a long meeting. He estimated 2 hours. I think I estimated 45 minutes. One of us is probably a better estimator of time than the other, but it was certainly the longest of the meeting. My recollection for the meeting when he picked up the report is it was a relatively short meeting. He presented us with the report. I think that I or somebody else noticed that the date on the report, which was supposed to be the day we were picking it up, was incorrect, and we asked him about that. I think they reran it with the correct date on it. Other than that, we went over the report in a kind of at least from my point of view, kind of a perfunctory fashion, because I already knew the information that was in it. And, my concern was to get back and get it out to everybody before that day, before the end of that day.
What steps did you take to make certain that the information relating to the DNA from non-lacrosse players that were found on items on the rape kit were reported in that report?
I didn't take any steps. That wasn't on my mind when I looked at it. I mean, I hadn't taken any reports, pardon me, any steps to keep it out. I didn't take any steps to keep it in because I really just didn't notice that it wasn't there. I was looking at I knew that nothing had been found that implicated any lacrosse player except for Dave Evans on the fingernail. And that was the whole point of my sending the information over there had really been to see if we could get something off the fingernail. So I had considered that to be good news for the investigation, but hadn't really thought about the other matters and continued not to think about them.
At the time that you obtained that report, you had already received indictments against Mr. Kennedy and Mr. Seligman, had you not?
Yes, sir.
And so, as well as the requirements of 15A-282, you were operating under another statutory requirement. Is that correct?
Yes, sir. I think clearly the discovery statute, 15A-903, requires, at least to my view, requires more of a response than 15A-282. And I believe that the intent of 15A-282 is that if you take a non-testimonial sample from someone for use in a criminal case, then that person is entitled to know whether or not that sample in any way connects into that case. And that's what, why we make the response in 15A-282. Clearly, that is not all the response that needs to be made in 15A-903. So a response that was satisfactory under 282 would certainly not necessarily be satisfactory under 903.
What did you do with the report that you obtained on May 12, 2005?
We returned to the office immediately. I may have actually made the copies myself of this report in the sense of putting them in the copy machine and running off the copies. But again, I believe it was Ms. Clark that had the arrangements or made the arrangements to contact the attorneys and let them know that those reports had been received. One reason that I wanted to get back to the office and get these done was that I was scheduled to go with my family out of town that weekend, and I couldn't leave until we completed this task. And so I wanted to make sure that it got done before I left town.
From May 12, 2006 until December 13, 2006, how often did you go back and review the report that was prepared by Dr. Meehan on that date?
I don't know that I ever reviewed it. I mean, I obviously had it. It was in the stuff that we had been collecting in order to provide discovery. And what we did in order to comply with discovery is after indictments were returned, we had the investigators bring over, I said, bring over everything that you have in this case. I don't care what it is, everything that you have. And they brought over, I guess the documents they brought over would probably, 2.5 feet maybe or something, I don't know, a little over 2 feet, worth of papers in I think that it was brought over in the boxes that you have reams of paper in for copy machines and things like that. They had something along those lines. And it was divided into manila folders that contained various numbers of pages. And so what I asked my administrative assistant to do, actually it was, the person who did this was Sheila Eason, who was in the investigative slot at the time, which is a complicated story, but I asked her to make copies of everything exactly the way that they appeared in the file, so that if the first manila folder that the officer had something written on the outside, whatever that was, she was to write it on our folder and then make sure that the contents of that folder were exactly the same as the contents of his folder, so that when that procedure was completed, we would have presumably an exact duplicate of the officer's file. And she did that over a period of maybe 3 days. It was not something that could be done all at once. And so then, after that, at some point before we complied with discovery, other people in my office went and numbered every one of the pages by hand, so that And then I think maybe I went back and numbered the outside of the folder to say this folder contains pages 117 through 135 or something like that, to help us if we ever had to come up with that particular folder or that particular page. And then as additional material was received in the discovery process, I would make the additional folders and would label the folders and would number the pages and would put them, and there was a separate box for files that had already been produced in discovery and for ones that had been received but not produced, to help us make sure that everything got turned over. So that was the procedure. It is certainly possible that I dealt with that particular folder, but in terms of actually going back and reading it, I don't believe that I did. Excuse me, let me get a little more water.
Yes. Yeah. All right.
Thank you.
Let me backtrack just a little bit. The photo presentation occurred April 4th, 2006. Is that correct?
Yes, sir.
April 17th, 2006, indictments were returned against Mr. Finnerty and Mr. Seligman. Is that correct?
Yes, sir.
What information other than the identification of those gentlemen in the photo presentation do you believe was there to present to the grand jury as of April 17th to return those two true bills?
I don't know what information was presented to the grand jury, but the indictments were based on the identification of Mr. Seligman and Mr. Finnerty by Ms. Mangle.
Do you believe that that photo presentation is a photo array that would have been covered by... Did you know about the general order the Durham Police Department had back in April of 2006?
I'm not sure if I knew at that point that that was part of the general order or not. I did know about the general Innocence Commission guidelines with respect to how that was conducted. And subsequent to that, of course, I knew that Durham did have that in its general order, but whether or not I certainly wasn't thinking in terms of whether or not Durham had that as a general order at the time that we did this procedure, because I didn't consider it to be a lineup.
What did you consider it to be?
I don't know what you'd call it, a presentation of photographs. To me, it seemed like a lineup was something that you needed a suspect in, that you put somebody that you believe committed a crime in with a bunch of people that you believe did not commit the crime, to see whether someone can pick out the person that committed the crime. And in this situation, my belief was that we had a minimum of 43. We had 46 photographs. So a minimum of 43 of those would be people who didn't commit the crime. And that quite possibly none of the people in those photographs would be people who committed the crime. Because the only evidence that we really had that the people who were there at the party that night were lacrosse players came from lacrosse players themselves. And so we did not know whether there were other people there who could have committed a crime. We did subsequently learn of a Mr. Brett Baumler, I believe is his name, and William Baumler and a Mr. Brent Saley, S-A-E-L-I, who were fraternity members and friends of somebody who had been at the party. They were not listed on any of the lists of people that were there. So we did not know who was present at the party, and we did not know what, if anything, the condition was going to be. We were looking for anybody who could give us information that, who maybe could give us information if we could approach them by saying something like, we have reason to believe that you had some interactions with our victim that night. Do you want to tell us what you know? And that was really where we were going, to see if we could get anywhere with that. Because it obviously hadn't, whatever my intentions were, it had not worked to try to get people to come forward by making public statements appealing to conscience and things like that. It had not worked to tell lawyers, if your client has any information they want to give us to help us with this investigation, please have them make an appointment with Mr. Gottlieb or Mr. Hyman.
Did you consider anybody present at the house that night a suspect at that time?
I did not. I understand that some people, would say that because the people there were lacrosse players, that all the lacrosse players were suspects. But to me, this was more, and I actually heard somebody use the analogy, although not quite in the way that I would have. It's more similar to the situation where somebody says, I don't know the name of the person who did this, but I remember that they were in the class ahead of me at such and such a school. And so you go back and get the yearbook from that particular year, and they go through there and they pick somebody out and say, that's the person. In other words, I looked at the lacrosse team as the universe which may or may not contain the suspects in this case. But we didn't have any suspects until we had evidence that connected somebody with the crime. And at that point, we didn't have that.
And the universe could not be larger than who was there at the house. It couldn't be larger than the lacrosse team at that time, could it?
Well, at that time, all we knew, the only people that we knew were there from the lacrosse players were the lacrosse players themselves. And we did not know that all those lacrosse players were there.
But to put it in your mathematics teacher terms, the set of possible people who could be suspects were A, those who were at the house that night, and B, to your knowledge at that time, they were all lacrosse players, correct?
Well, I would say that the set, putting it as a mathematics teacher, the set of all lacrosse players was the portion of the set of all people that could have been at the house that night of which we were aware.
All right. Minus one?
I'm sorry.
Didn't you exclude the sole African-American player?
Yes, sir. I should have referred to the Caucasian lacrosse players. Her identification of her assailants was that they were all white males. So we were not looking at any African-American males as suspects ever in this case.
So you excluded the one based solely upon that assertion, correct?
Her assertion that all of her assailants were white males, yes, sir.
All right. I'm sorry, Mr. Williams. Go ahead.
Mr. Chairman, just thinking along the lines as we discussed yesterday, this might be a good time to take a lunch break because we have that other piece of evidence that we talked about. You want us to?
Yes. Why don't you put that on the record as to what we discussed yesterday that we would do during the lunch break?
We had discussed yesterday that one of the exhibits that the defendant has is a tape of the photo presentation that was prepared by Detective Hyman for the State Bar and myself that we received. I believe it was May 18th, 2007. They didn't have the ability to put the cassette tape in, because I understand the State Bar has been gracious enough to download that cassette tape into their CD program. So what I would do is mark as, I believe it's Defendant's Exhibit 3, the cassette that was provided by the Durham Police Department for counsel for both parties on May 18th, 2007. And I would suggest presenting that at lunchtime so that you and anybody that wants to be in here watching it can view it during the lunch break so that we can speed up the process this afternoon. And I believe that's what we discussed yesterday with counsel for the State Bar.
And I understand that's acceptable to you.
Yes, sir.
All right. Yeah, just to be clear, what we're going to do, since the hearing committee's practice has been to sit in this room and eat our boxed lunch during the lunch hour, that we will watch that exhibit and that it will be considered to be received by us, but we will not take up any formal hearing time to do that. We will not ask that the room be cleared at that time. Anyone who wants to stay for to watch that can do so. Correct? That's fine.
Yes.
All right. Well, that's what we're going to do. How long is that?
I believe it's 46 different photos. If I remember correctly, they were a minute a photo, so it's 46 minutes. And if you give me a second, I'll look at the transcript. I think it's
I bet it's longer.
not a ton. How long is it?
Is it marked on there how long it is?
He'll know how long it is.
2006 at
An hour,
An hour?
at least.
Okay. Why don't we do this? It's almost 12. Well, it's 12:25 by my watch. Going by the clock, let's reconvene at 1:45. All right, we're in recess.